Chesapeake Bay Foundation is nearly 50 years old, with programs ranging from environmental education to oyster restoration to advocacy work. We have 15 separate environmental education centers all around the Bay, from upstate Pennsylvania to Western Virginia and over to the Eastern Shore. We also have offices staffed in Virginia, Maryland, Pennsylvania, and Washington, D.C. Washington, D.C., what one pundit recently called 68 square miles of confusion surrounded by reality. In Hampton Roads, our office is about to move from a collection of small closets here in Norfolk to what we believe may be the greenest building in the world, the Joan and Macon Brock Environmental Center. It's coming out of the ground as we speak in Virginia Beach, the property known as Pleasure House Point. The buildings will be net zero energy, net zero waste, and net zero water. Now let me offer just a word or two about the Chesapeake Bay. It's getting better, but it's still a system dangerously out of balance. Oysters are thriving, underwater grasses are starting to return, and the dead zones are finally beginning to recede. We have a long way to go, but at least we're going in the right direction. Across this great country, water quality is increasingly seen as a critical concern. Let me read you just a few quotes from some papers around the country. The Des Moines Register, editorial, August 7th. When officials said it was unsafe to drink or even bathe in Toledo, Ohio's municipal water supplies last weekend, it was a major inconvenience for 500,000 residents. It was also a wake-up call to the rest of the nation to the fact that water pollution can directly affect the health of humans. The New York Times, Dateline, Olympia, Washington. Billions of baby oysters in the Pacific inlets here are dying, and Governor Jay Inslee of Washington is busy spreading the news. The Virginian Pilot, August 12th. For more than a decade, scientists and policymakers have known there is something terribly wrong with the male fish leading to the Chesapeake Bay. They grow female parts. They produce eggs. The research found a correlation between intersex fish and heavy agriculture and municipal treatment plants. And lastly, from the International Business Times, August 16th. Following a long description of crises around the country, they wrote, "At least one region, however, has policy advocates optimistic: the Chesapeake Bay. Federal regulators established a limit on how much pollution would be allowed to reach the estuary." And then they quoted a CBF scientist who said, "We feel like we have a good framework here for success. We just need to implement it, and that requires political will." We have a lot to celebrate here on the Chesapeake. Certainly we do have a lot to worry about, and we have a lot left to do. General Herring was the first Attorney General in the country to stand up and support the pollution reduction protocol mentioned in that International Business Times article. That protocol is being challenged by a collection of agricultural industry lobbying associations. They are suing EPA, the Chesapeake Bay Foundation, and others. General Herring and now a number of other Bay State Attorney Generals are fighting back. General, we are truly grateful for your leadership, and we are looking forward to your remarks tonight. But first, let me tell you that at each of your places, you have a little card. If you may write questions, pass them to the middle aisle, and ROTC students will be collecting them, and hopefully General Herring will have time to take a few questions afterwards. And now it is my distinct honor to once again thank Old Dominion University and introduce Earl Nance, General Counsel of Old Dominion. Earl.
Good evening. It is our pleasure to welcome you to Old Dominion University for the Blue Planet Forum. It's such an honor to partner with the Chesapeake Bay Foundation to educate and engage citizens on important environmental issues facing Hampton Roads and beyond. ODU has been a hub of research and education in coastal engineering and ocean sciences for decades. 4 years ago, we formally launched the Climate Change and Sea Level Rise Initiative as a collaborative undertaking among the university's 6 colleges. This initiative also brought together stakeholders from government, industry, and environmental groups for workshops with ODU faculty members, and it's included several public forums. Earlier this summer, ODU hosted TechSurge, technical support for coastal resiliency, a first of its kind conference for government and industry planners to develop a comprehensive local strategy to combat increased flooding that will serve as hopefully a national pilot project. Our Attorney General recently visited Old Dominion, and he was briefed on the university's 2 main research initiatives: climate change, sea level rise, and bioelectrics. He seemed quite interested because he's returned now to visit us again. And Mark Herring was sworn in as Virginia's 48th Attorney General in January of 2014. Prior to becoming Attorney General, he served 8 years in the Virginia State Senate, representing Loudoun County, where he was raised and where he and his wife Laura raised their 2 children. Mark got his start in public service as a member of the County Board of Supervisors in Loudoun, and he has been an attorney in private practice for 20 years. As Attorney General, he is working to ensure the office meets the needs of a rapidly changing Commonwealth. He is working with Virginia law enforcement to respond to the public safety threats of today and to prepare for the challenges of tomorrow. His top priority is finding ways to use the law and the powers of the office to promote justice, equality, and opportunity for all Virginians. Attorney General Herring's responsibilities notably include enforcing the laws protecting Virginia's environment. In April of this year, he demonstrated his resolve to honor that responsibility, as Will pointed out, for the Chesapeake Bay by filing a Friend of the Court brief in support of the Chesapeake Bay TMDL, often known as the Chesapeake Clean Water Blueprint. That brief, filed in the Federal Appeals Court in Philadelphia, highlighted the Chesapeake Bay's historic and economic importance to Virginia and eloquently defended the right of the Commonwealth and neighboring states to partner with the Environmental Protection Agency under the blueprint to restore the bay. The importance of his voice as Virginia's voice in that legal battle cannot be overstated. On a personal note, my colleague Jay Wright and I, who have the honor of serving Old Dominion as counsel, we have found General Herring's leadership to be both encouraging and very inspiring, General, and we are deeply grateful for your presence here. President Boderick, on his behalf, we welcome you. Hope you will return many times. Ladies and gentlemen, Attorney General Mark Herring.
Good evening, everyone. I am really glad to be here tonight. It's great to be back at ODU. It's wonderful to see students and faculty and members of the community and so many proud guardians of Virginia's natural resources. I would like to take just a moment before I start to also thank ODU for hosting us tonight and President Broderick. I'd like to thank Will and the trustees of the Chesapeake Bay Foundation and everyone else associated with the foundation for your environmental stewardship and your advocacy for the Chesapeake Bay. And Earl, thank you very much for that introduction. What he also didn't say is he sort of had to say nice things about me. The General Counsel of ODU works in the Attorney General's office, so, but I hope some of that might have been heartfelt. And I also wanted to point out one other person. John Daniel, who's in the front row, is one of 5 Deputy Attorneys General. And John oversees the Commerce, Environment, and Technology Division in the Attorney General's office. He's a great lawyer. He has worked really hard on a lot of these environmental issues, not just since I've taken office, but over the years. And he also was Virginia's first Secretary of Natural Resources under then Governor Belials. So thank you for joining us tonight. The history of the Commonwealth is inexorably linked to the land and waters that have supported us since English settlement. And Virginia has an unparalleled wealth of natural resources and natural beauty, and we take seriously our responsibility to pass on to the next generation the bounty that we've inherited. As Attorney General, I believe vigorous protection of our natural resources is an inherent part of the job description of the Attorney General. Now, in part, that is driven by certain statutorily assigned duties, such as working with the Department of Environmental Quality to bring enforcement actions and make sure that the permit rules are being followed. But it's also because it's in the public interest to protect our environment and natural resources. I'd like to take just a moment, though, and explain what I mean by because it's in the public interest, that it's a part of the job description of the Attorney General. Now, if there are any legal historians in the room, I need to apologize because I'm going to shrink about 7 centuries of Anglo-American jurisprudence into about 7 sentences. But the Office of Attorney General actually has a very storied past. And it originated back when the courts of medieval England were first getting started. And it didn't take very long before the kings and the queens figured out it was a good idea to hire a lawyer to protect their money and property. Now, over time, as England developed, that became an official office with deputies, assistants, and a staff. And that concept came across the Atlantic during colonial times. But then, after the Revolution, when the United States was established, the job of Attorney General changed in America. And instead of defending and protecting the interests of the king, it was about defending and protecting the interests of the public. And it is in the public interest to protect our natural resources for the enjoyment of all Virginians by enforcing laws that protect our resources and going after those who run afoul of our laws. Now, maybe that's not something that has been a high priority for some recent attorneys general, but it has been a high priority of mine since the first day I took office. And it's not just that I happen to believe that environmental stewardship is important, or that I've traveled all over Virginia the last few years listening to Virginians and hearing that it's important to them, although both of those things are true. But we as a Commonwealth take our obligation to care for the natural resources so seriously that we have written it into our Constitution. And Article 11 of the Virginia Constitution states that it shall be the Commonwealth's policy to protect its atmosphere, lands and waters from pollution, impairment, or destruction for the benefit, enjoyment, and general welfare of the people of the Commonwealth. Now that is a powerful expression of the value we as Virginians place on our natural resources. And as our bay restoration and general environmental improvement efforts come under legal attack from special interest groups, we need to be prepared to vigorously defend them on both good legal reasons and also good public policy reasons. So this evening I'd like to tell you a little bit about some of the things that I've learned working on these issues at the state and local level, some of the challenges and opportunities in front of us as a state, whether it's in the field or in the courtroom or in the State House, and why it's so important that we pursue a cooperative and collaborative relationship with economic development and environmental quality. Now, my background as a lawyer is mostly on the civil side, and in private practice I did a lot of work on municipal planning and land use issues. And because of that background, after I was elected to the Loudoun Board of Supervisors, I served as the board's chair of the Land Use Committee. And at that time, I was, and still remain, a strong advocate for smart growth. The agricultural Loudoun County that I knew when I was growing up was quickly being transformed into one of the fastest growing suburban communities in America. And I was convinced that we needed a plan to grow in a smart, sustainable way, and I knew that unplanned or poorly planned growth could tarnish our corner of the state as well as those areas downstream. Now, while I served on the board, I helped to do a number of things to promote environmental quality, things like leading an effort to rewrite and overhaul our county's comprehensive plan to better link transportation and land use planning. Supported a new program for the purchase of development rights that later became a model for other localities. I helped create the county's environmental and historic resources program and oversaw an overhaul of our erosion and sediment control program. I also had an interesting experience on the Potomac Watershed Roundtable. I think because of my position as chair of the Land Use Committee, it sort of put me automatically on the Potomac Watershed Roundtable. This was in the early 2000s. It was kind of a precursor to the coordination that would be required years later for the Bay Blueprint. And I remember we were talking about TMDLs for the Potomac watershed and other watersheds. And I felt frustrated because I could see that it was going to require a lot more effort and a lot more coordination if we were going to achieve our goals. But now, as I reflect back on it, those efforts were not wasted. Not in the Potomac watershed or any of the other watersheds, because I think it was a real turning point in getting local and state leaders to get those who are active in the community to see the connection between what we do on the land and the quality of our streams and rivers and ultimately the bay. So I knew that we needed to do a lot more, and that experience helped us to get to where we are. Now, those are things that scientists and advocates have known about for a long time, but it wasn't necessarily well understood elsewhere, and over time I could see people were understanding it and getting it. And things like impervious surfaces and dealing with stormwater on site, low impact development, over-fertilizing, and all of the other activities that affected the watersheds. These were things that at the local level we were beginning to understand better and better thanks to those early efforts of 10 and 15 years ago. Now, as a state senator, I supported things like public transit projects to reduce environmental impact, sponsored legislation to require a mandatory energy efficiency standard, and to help grow the state's clean energy sector. I opposed efforts to mine uranium in the Commonwealth, and I was also the first elected official to oppose my predecessor's attack on a climate scientist working at UVA. Well, now, as Attorney General, I've got an opportunity, with your help, to really fulfill that promise in our Constitution to care for and protect our natural resources. And we've already had one big opportunity that we seized when we became, as Will said, the first Bay state to defend the Bay Restoration Plan in a lawsuit that's trying to get it thrown out. Now, for those of you who don't know much about the lawsuit, as Will said, it's some national industrial scale agricultural interests who filed a lawsuit against the EPA saying that the current Chesapeake Bay cleanup plan is illegal. They claim the TMDL blueprint, which was developed by Bay states and entered into voluntarily, the plan, which is the single most promising effort to restore the Bay, is illegal. So let's take a minute and run through how the plan was developed, because it's really at the heart of the legal challenge against the plan. We start about 30 years ago, in 1983, when the first Bay Agreement was voluntarily signed by Pennsylvania, Maryland, and Virginia, with Governor Chuck Robb signing for the Commonwealth. The three states basically signed an agreement that said, the Bay is really important, and it's really dirty, and we should work together to clean it up. Now, it was a rudimentary plan, but it was an important first step in recognizing a shared responsibility and a commitment. Now, you fast forward to 1987. The second Bay Agreement was signed by then Governor Jerry Baliles. And the states said, if we're going to reach our ultimate goal, we have to take a data-driven approach and set concrete goals and deadlines. So the states created self-imposed goals of a 40% reduction in nitrogen and phosphorus by the year 2000. And then we had the Chesapeake 2000 Agreement, which was a much more technically refined document that laid out our pollution reduction goals. And it coincided with the federal Chesapeake Bay Restoration Act, which recognized the need to expand federal support for monitoring, management, and restoration activities in the Chesapeake Bay and the tributaries of the Bay in order to meet the goals of the program. Congress specifically directed the EPA administrator, in coordination with other members of the Chesapeake Executive Council, to ensure that management plans are developed and implementation is begun. Around this time, some environmentally minded organizations brought suit against the EPA for failing to fulfill its obligations under the Clean Water Act. Now, under the Clean Water Act, states are required to set their own goals for reducing pollution in their waterways, and when a state fails to meet its goal, that waterway is supposed to be listed as impaired, which requires the state to create an implementation plan to fix the waterway. Now, these legal actions were brought all throughout the watershed, and in Virginia, we voluntarily entered into a consent decree, which is basically a settlement agreement, stating that Virginia would reduce its pollution into the Bay by 2010. And if we failed to hit that goal, we would work with the EPA to develop a TMDL, or total maximum daily load, which is essentially a pollution diet. The EPA had actually started working on the TMDL for the watershed around 2000, and working with state scientists, regulators, governors, and others to figure out what the entire TMDL should be. And around 2007, it was pretty clear that we were going to miss the mark for 2010. So after years of studying the Bay, its watershed, the EPA set the TMDL for the entire watershed, then divvied it up, giving each state their pollution reduction goal. At that point, each state went to work developing a plan called a Watershed Implementation Plan, or WIP, to meet their goals. Virginia's plan was developed by the administration of Governor Bob McDonnell, continuing a proud tradition of leadership on the Bay by Virginia governors of both parties. And that process was completely transparent and provided extensive and ample opportunities for the public and stakeholders to be heard. So what's the bottom line in all this? History shows that the Bay States have led the charge to protect the Bay through concerted efforts by and among all of the concerned jurisdictions. To be sure, as Congress required, the EPA has been an important partner in these efforts, but it reshapes the facts beyond recognition to portray these efforts to protect the Bay as anything other than an example of the states working with the EPA together to protect a regional and national treasure. So that's how we got to this point. We've got a plan that represents the individual choices of each Bay state, and it's a plan that's showing real promise. Now, these national industrial scale agricultural interests feel threatened by the plan. Because if the EPA can work with the Bay states to clean up the Chesapeake Bay, they might work with other states to limit pollution and clean up other rivers. The horror. So these big agricultural operations brought suit in Pennsylvania, and it was heard by Judge Sylvia Rambo. So what were they actually arguing? Well, I think the legal issues here are worth briefly discussing because they're easy to understand and there's a lot of misinformation out there. The questions before the court were, first, whether the EPA was acting reasonably in helping to develop the blueprint as part of its responsibilities under the Clean Water Act. Second, whether the plan was based on sound science. And finally, whether the public had an opportunity to weigh in on the proposed plans as they were being developed. Let's take them one at a time. Was the EPA acting reasonably in working with the states to help develop an implementation plan? Well, in the trial court, Judge Rambo said yes. In fact, the states were the driving force in developing their individual portions of the plan. And the judge found that this process was not at all the coercive power grab that the opponents have tried to make it out to be. It was a model of cooperative federalism, with states looking out for their interests while working with other states and the federal government to address a problem that is bigger than any one state. To quote Judge Rambo, "The record reveals that the partnership undertook significant efforts to preserve the framework of cooperative federalism as envisioned by the Clean Water Act, and that the EPA did not unlawfully infringe on the Bay States' rights." So the opponent's first claim fails, and that's strike one. Second, were the states and the EPA acting according to sound science? Again, in the trial court, Judge Rambo said yes. The opponents of the plan were trying to show the agency acted inappropriately in selecting their scientific methodology, but the court found otherwise after going through a very extensive analysis of the scientific underpinnings of the program. That's strike two. And finally, did the public have a meaningful opportunity to weigh in on the development of the blueprint? And again, the judge ruled an overwhelming yes, and that is strike three. And in Virginia, for example, our portion of the blueprint was developed over many years with significant, perhaps an unprecedented amount of input from the public and stakeholders, agricultural interests and watermen, developers and conservationists, local and state officials. Just like Virginia has always done, we worked to develop a plan that balanced our environmental goals with our fiscal realities and smart planning with the land use prerogatives of local government. So the plan was developed within the bounds of the law, it was based on sound science, and everyone, including opponents of the plan, had ample opportunity to weigh in. Now, after these folks had their arguments pretty thoroughly dismantled in court, they appealed to the Third Circuit in Philadelphia. And this time, they brought some backup. 21 states attorney general from 21 states, none of which even touch the Chesapeake Bay, filed a brief attacking our cleanup plan. 21 attorneys general from as far away as Utah, Montana, North Dakota, Wyoming, Texas, even Alaska weighed in through the courts attacking our bay restoration plan. I remember sitting in my kitchen having breakfast, reading the article in the Post when it was filed, and I thought, what did our Chesapeake Bay ever do to Alaska? Well, as Attorney General, I wasn't about to stand by and allow attacks on our plan to protect our waters to go unanswered. So I filed a brief in the case on behalf of the Commonwealth of Virginia and our Bay Restoration Plan. Now, in law school, they teach you that if you're going to file an amicus brief in a case, you want to make an argument that really the parties aren't already making so that you can add something for the court. So our contribution to the case was a clear articulation of the importance of the Bay, the long and productive history of cooperative federalism on issues related to the Bay, and a clear declaration from a Bay state that we believe the process that led to this plan is both sound policy and legally solid. We made it clear that the Bay has ecological, economic, and intrinsic value to Virginia. We hunt and fish here. We boat on these waters and play on these shores. We eat so many foods sustained by these waters, and tens of thousands of men and women make their living on the water, generating billions in economic activity. But it all depends on a clean bay. We told the court that for centuries we have worked voluntarily with our neighbors, and more recently with our federal partner as well, to manage and care for the Bay and the waters that flow into it. The Bay states asked the EPA to help coordinate this effort because the Bay watershed is 64,000 square miles, over 6 states and the District of Columbia. Now, Virginia has never been a state to concede much power or sovereignty to the federal government, and we haven't done so here. Now, unfortunately, several of Virginia's own congressmen have recently taken up the side of Big Ag over the health of the Chesapeake Bay. They joined another amicus brief from a number of legislators trying to make the argument that the EPA was acting illegally and exceeded its authority. But that's just not the case. In response to the congressman, my friend and Bay Foundation trustee, Harry Lester, along with Andrew Fine of Lynn Haven River Now, responded, and they really nailed it. They said, the congressmen are mischaracterizing this cooperative, very public plan as some kind of illegal misappropriation of federal power. For more than 30 years, Virginia has been actively engaged in working with the EPA to restore the Bay. 3 Virginia governors representing both political parties have endorsed the blueprint and its goals. It's just common sense and good government to have the EPA to coordinate this effort. Well, it is common sense. It's good government, it's within the law, and it's working. As I said, the case is currently on appeal before the Third Circuit in Philadelphia. We hope we'll have an argument soon because we're moving forward with the implementation of the WIP, and we're making good progress. The blueprint says that by 2017, we should have in place 60% of the programs that will help us meet our goals. And as of June of this year, the EPA has told Virginia we're on track to hit the mark for 2017. We actually finished the 2012-2013 milestone period ahead of schedule. We were 2.4 million pounds ahead of schedule for nitrogen reduction, 500,000 pounds ahead for phosphorus, and 74 million pounds ahead on sediment. Now, the EPA estimates that by the end of 2015, we're going to see a total reduction of 7.9 million pounds of nitrogen, 1.1 million pounds of phosphorus, and 404 million pounds of sediment compared to our 2009 baseline. So as a whole, we're doing well, but if you break the whip down by sectors, it shows that we still have some hard work to do. Now, the biggest reason that we are on track to hit our 2017 goals is because of some really good work on point source pollution. So it's generally wastewater treatment plants and industrial sites. In stormwater, we've got some new regulations now regarding storm runoff that have just gone into effect in July. Once they're fully implemented, this program should be a more effective way to control runoff and protect water quality. As our state continues to grow, it sets goals that are achievable. And in the last 50 years, Virginia's population has more than doubled, yet we've still managed to reduce our pollution discharges, and these new regulations are going to continue that trend. The state has also made about $30 million in matching funds available to localities through the Stormwater Local Assistance Fund for things like pond retrofits, permeable pavement, and stream and wetlands restoration. Now, in the area of stormwater, we've installed plans to limit the nutrient and sediment impact of future development, and we're taking steps to reduce the impact of existing development. In agriculture, we primarily rely on voluntary measures and cost assistance to meet our nutrient reduction goals. You may have read last Monday, Governor McAuliffe launched the RMP program, or Resource Management Plan. And this offers real promise to help us meet our pollution reduction goals in agriculture without overburdening family farms or small agricultural operations. Now, the way it works is this. The state provides a certain level of cost sharing for agricultural operations that institute best management practices. In exchange for implementing these best practices to reduce runoff, the farms get assurance that they will not be required to meet additional TMDL related regulations for 9 years. So they make improvements now and get assurance about what will be required of them in the foreseeable future. And that is a balanced and sensible approach. The cost sharing is also a really important part of that because, especially with regard to measures to do stream exclusion, to keep the cows out of the streams, the state will pay 100% of those measures. So beyond bay restoration, I think there are a number of things that we can do to improve water and air quality, improve health, and create jobs along the way. I'm sure many of you have followed closely the situation on the Dan River, where a coal ash spill dumped several thousand gallons of power plant byproduct into the Dan River. And the Dan is where a large portion of Southside Virginia gets their drinking water. Now, fortunately, investments made in environmental infrastructure have paid off, and we appear to have avoided what could have been a real catastrophe if there had been contamination of the water supply. In the months since then, we've worked with DEQ on environmental evaluation. We have secured a commitment from Duke Energy to meet its responsibilities to the people of Southside. That was a message I personally delivered to Duke Energy following the incident, and it was a commitment I made in person to the people of Danville during a meeting in the region. We've also worked on a number of conservation easement cases because open space preservation is one of the best things we can do for clean air and clean water. And also because the saying is true, once it's gone forever. Now, you might remember a little bit earlier, I mentioned as Attorney General, it's my job to go after those who violate our environmental laws and damage our waterways. I also mentioned how that might not have been a priority for some recent attorneys general. Let me give you an example. Very early in my term, we found out that several states had settled a major lawsuit against Alpha Natural Resources for more than 6,000 permit violations involving waterways near its coal mining operations. This included hundreds of violations in Virginia. West Virginia, Kentucky, and Pennsylvania filed suit to stop these violations, receive compensation, and get guarantees from Alpha that they would upgrade their operations to avoid future violations. Let me run those states by you again. West Virginia, Kentucky, Pennsylvania, all coal states, still felt these violations were so blatant and rampant they needed to file suit in court. Virginia was approached by the EPA about getting involved and last year chose not to be a party. Well, we are now. Unfortunately, by the time we got into office, it was too late to receive the financial recovery that we should have received. But we were able to get involved in the case and make sure that Virginia has access to all the scientific data on our waters that might be affected by these violations. And there are stipulations in the agreement that would make Virginia eligible for compensation if any of the mining companies fail to live up to their obligations. The Bristol newspaper had a big article a few weeks ago about how the Clinch River and other outdoor recreation opportunities were helping Southwest Virginia to diversify and strengthen its economy. That's something that Virginia leaders have been talking about for years, and it's starting to happen. But Southwest is going to have a really hard time attracting businesses or workers or tourists if the rivers are fouled by reckless operators upstream. Also, right now we're looking at the new proposed rules related to carbon emissions. It's a complicated proposal that involves energy efficiency measures, lower carbon sources of energy, renewable energy, and tighter controls on existing generation facilities. We've got our client agencies and attorneys working together with the stakeholders from conservation and industry to try to find the right balance between costs and conservation goals. And to me, that's exactly how it should be done. So why does all this matter? Why do we even bother fighting for things like clean air and clean water and open space preservation? Well, first and foremost, it's because we want a healthier environment and healthier Virginians. But we should also point out to any skeptics that there is also a very real secondary benefit, which is the creation of jobs and economic activity along the way. And furthermore, not meeting our environmental commitments has a cost too. So first, let's talk about the impression, or the misimpression, that some want to create a diametric relationship between economic strength and environmental successes. I don't consider that an either-or choice. I know you don't either. Economic strength and environmental success are interdependent goals, and that symbiotic relationship is a major reason we should pursue environmental improvements. In 2013, Forbes magazine recognized Virginia as the best state in America for business. As a part of that analysis, Forbes looked at a number of different factors that would make a business want to operate in each state. Virginia ranked in the top 5 for both economic climate and quality of life. Now that tells me a few things. It tells me that as we're pitching Virginia to potential employers, or trying to get businesses to stay in Virginia to grow and expand, we need to make a strong case for high quality education, for reasonable regulation and taxation, and we need to be able to make the case that in Virginia, workers and their families will be able to live happy, healthy lives. So key to our economic success is a credible case for a healthy environment and a high quality of life based on clean air, clean water, and outdoor recreation opportunities. Now let's turn the equation around a little bit. As our Commonwealth continues to grow, we will need to take steps to mitigate the effect on our environment. And we all know we're still working to undo damage from previous neglect and abuse of some of our waterways. Some of you may remember Keepone and the James River. Now, these are important and necessary investments for a number of reasons I'll mention in a moment. But they are investments, and they require capital. And if there's going to be public investment, that's going to mean tax revenue. That, in turn, requires a strong economic activity from the private sector, much of which probably chose to locate or expand in Virginia, at least in part, because of our high quality of life. So economic activity generates the revenue needed for investments in environmental efforts, which then attracts more economic activity, and the cycle continues. Now, it is certainly possible for that cycle to break down. If we overload one side of the equation, either by throwing off all regulation and wrecking our environment, or by clamping down so hard on businesses that they can't operate profitably, then we'll damage both. Now, while we haven't always gotten that balance exactly right all across the state, Virginia has gotten high marks for generally striking a good regulatory balance. Sometimes we have to adjust because we've missed the mark. Sometimes because we get better information. Sometimes because new technology changes the cost-benefit analysis. But it's critical to our environmental and our economic success that we get this balance right. And I'm committed to see that we do. We should also point out that dirty water and dirty air cost money too. Now, if you look at California, and admittedly California has a much more serious air quality problem than Virginia, but it makes an important point. The Rand Corporation did a study a few years ago and said that between 2005 and 2007, dirty air resulted in $193 million in hospital care spending in California. Things like asthma and other respiratory problems are clearly linked to dirty air. And dirty water also has a cost. Will mentioned Toledo in his opening remarks. Now, when I learned about that, my wife and I were cooking dinner. Actually, my wife was cooking dinner, I was keeping her company. And she got a call from her sister who lives in Toledo, so I took over stirring the beans. And she yelled across the kitchen, "Mark, Jen says they don't have any drinking water in Toledo." And I was like, well, surely they've got treatment plants, right? And then she went on to explain that because of algae blooms in, if my geography is right, Lake Erie, that toxins got into the drinking supply and shut down the whole drinking water system for a major U.S. city. Well, a little while ago we learned that similar algae blooms were showing up in the tidal James, fed by the same types of runoff. And once these blooms die off, they lead to dead zones, and that makes the problem even worse. As we're making decisions about conservation, or remediation, or land use, we have to carefully weigh the economic, social, and environmental benefits alongside the costs. Like when a doctor is plotting a course of treatment, he or she doesn't just consider the cost of treatment or the possible side effects of that treatment. Those concerns are weighed against the benefits of treating the problem and the immediate and long-term dangers should the problem go untreated. So not only do these investments have the long-term benefits of a healthier environment, healthier Virginians, and a healthier economy in the long run, but in the short term, we can see real economic benefits by creating jobs and raising our platform for economic success with investments in environmental measures. Upgraded water treatment facilities, improved stormwater management, runoff and erosion controls. All of these generate good jobs, particularly in the segments of the economy hard hit by the recession. And those jobs spread beyond the Bay across the Commonwealth. But even if you just look at the jobs and economic activity that occurs on the Bay, it's still one of the biggest economic engines we have in Virginia. The Bay annually contributes to the regional economy $2 billion and 41,000 jobs from commercial fishing, $1.6 billion and 13,000 jobs in saltwater angling, $70 million in crabs, $680 million in tourism. But every dollar and every job is contingent on a clean and healthy bay. So don't let anyone tell you that clean air and clean water are some kind of fringe environmental issue. These are issues that affect our economic and our physical well-being. Before I conclude, I would like to tell you how all of what we're working on in the environmental and natural resources area fits in with the larger framework of work that's being done in the Attorney General's office. Now, I think what you and other Virginians are seeing now and will continue to see in the months and years ahead is that we have an Attorney General now doing the things that a modern Attorney General should be doing. A modern Attorney General is going to make sure that the office is running efficiently. And that's why one of the first things I did when I came into office was bring in an outside group to do a top-to-bottom operations assessment to make recommendations on the technology and operations improvements to make sure the office is running as efficiently and as effectively as possible. A modern Attorney General is going to make sure that we're looking at not just the public safety threats that we've seen in the past, but the public safety challenges we're seeing today and those that we think we're going to see in the future, which is why one of the first things I did in the first couple of months was do a statewide 22-stop tour of Virginia, talking with local law enforcement and local prosecutors about the public safety challenges that they're facing and how our office can help them address it. A modern Attorney General is going to make sure that our business climate is one that allows our Main Street businesses to grow right alongside of our high-tech employers. And that's going to mean doing things that I'm doing now, like making sure our laws are being applied evenly and fairly and consistently so that business leaders will have the predictability they need in order to make long-term investment decisions in the Commonwealth. And that's also why I made sure that we are taking advantage of all of the talent we have in Virginia. And I looked at our in-state tuition laws and concluded that the children of certain immigrants, the Dreamers, currently under existing state law, have the right to in-state tuition, the opportunity for in-state tuition. And remember, these are the kids who have grown up in Virginia, they've gone to school in Virginia, they have overcome language barriers, they are exceeding in high school, they want to go to college and continue climbing the ladder of success and achieve the American dream. And I know that Virginia is going to continue to give them those opportunities. A modern Attorney General is going to make sure that Virginia is an open and welcoming place for all who would call our Commonwealth home. And I'm sure you know that I've been working for marriage equality since the beginning of when I took office. We won in court in Norfolk. We won in the appeals court in the Fourth Circuit. And I'm working to have the case heard as quickly as possible in the Supreme Court so the issue can be resolved for Virginians as well as the rest of the nation. And a modern Attorney General will defend the economic and the environmental interests of the people. And that is exactly what I intend to continue to do.
Please join me in thanking Old Dominion University and Attorney General Mark Herring. Thank you very much.
Thank you all very much.